This video may contain what could be considered attorney advertising under the rules of your state. This video is for information purposes only and should not be construed as legal advice. If you have a legal problem, it's vital for you to seek out and talk to a licensed attorney for advice. Good morning, good evening, good afternoon, wherever you may be. My name is Chris Simmons, attorney at law, and today we're going to talk about sanctuary cities. Now, this is a topic very near and dear to my heart. In fact, I live in Chicago, a sanctuary city. But the topic is too broad to cover in just one video, so we're going to break it into two. This video is going to cover the constitutionality of sanctuary cities, while the second video will deal with how they actually function. So without further ado, let's get into the constitutionality. There are two guiding principles that we need to understand in constitutional law to understand why we have sanctuary cities. First, we need to understand the Supremacy Clause. Now, this is a clause that is simple, but is very misconstrued and misunderstood, especially by those without a law degree who hasn't studied this. And that's because it's deceptively simple. Second, we need to understand what the anti-commandeering principle is. Now, in a nutshell, it means that the federal government has to use a carrot and not a stick to get states to do things, but it's a little bit more complicated than that. But let's get into this, and I think the best way to explain these will be to give examples. So I will do that as we go through this. So, Supremacy Clause first. Understand that our system is built from federal and state laws. They are two different sets of laws, and they often conflict. And the Supremacy Clause simply says when there is a conflict between the federal government and a state government in terms of laws, the federal government wins. That's deceptively simple in that that's not actually how it works, but it's a good basic explanation. How it actually works is more akin to federal laws acting as a floor but not a ceiling. And what do I mean by that? Well, you can go above and beyond the federal laws, but you can never drop below it. You can't go below the floor, but there's no ceiling for you to hit, unless the federal law specifically sets one. So, the easiest way to explain this is through minimum wage. So, I'm going to use State A and State B. The federal government, let's say, raises their minimum wage to $13 an hour. State A loves this. In fact, they think $13, that's too low. We're going to set our minimum wage to $15 an hour. State B is like, there's no way that's going to be viable. We don't like it. Why would that ever be a thing? So we're going to set our state minimum wage at $9 an hour. Both are a raise over our current, but they're two extremes, I think. So we now have a conflict of law. State A is in conflict with the federal government in that they have a higher minimum wage, and State B is in conflict as they have a lower minimum wage. So, State A is in the clear, and that's because $13 an hour is simply a floor. $15 is above that floor, and therefore you still pass federal law. You're just going above federal law. But State B has a problem. $13 an hour is the minimum. It's the floor. $9 an hour is below that floor. So State B's law is in direct violation with the federal law and has to be brought up to the federal law. So State B's law would have to be rewritten to incorporate $13 an hour. And that's basically how this works. Now, it also works in reverse. I'm not a scientist. These numbers are completely made up. And in fact, I'm not entirely sure this is the correct terminology. But let's play with it. The FDA, for some reason, says that lead in baby formula is acceptable in quantities of 5 parts per million. State A is like, yeah, we know that. In fact, we think it's more dangerous than that, and we want to set it at 3 parts a million. Nothing in our state can be sold if it has more than 3 parts per million of lead in baby formula. State B is essentially going to say 5 parts per million that's too low. There's no danger. It's not proven. 7 parts per million is perfectly fine. Again, made up numbers, probably not even the correct terminology. Not a scientist. I apologize to any scientists who watch this. But here's how this works. Both states are in direct conflict. However, State A, again, wins because the floor is 5 parts per million or less. Whereas there's no ceiling, which means 3 parts per million falls within the or less part. Whereas State B, 7 parts per million or 6 parts per million, whatever I had said, that's directly in conflict and is below that floor, in this case above the number, so it has to be brought down to the federal requirement. Now, there is one small thing. What if the federal government says that minimum wage must be $13 exactly? It cannot be lower or higher. Well, in that case, going back to the $9 and $15 an hour, both states are in direct conflict, and at that point, because the federal government has created a ceiling explicitly, both states would have to be brought down into $13 an hour. Most of the time, the federal government doesn't do this, but sometimes they do. I can't think of anything off the top of my head, but I believe it's mostly in things with precise measurements. Now, that entire thing was the Supremacy Clause. What's the Anti-Commandeering Clause? Well, the Anti-Commandeering Clause essentially states that the federal government cannot commandeer state resources to enforce federal law. Now, that may make sense or it may not, and it really depends on how you look at it. So, best example, easiest example, and it goes directly to sanctuary cities. Immigration is federal law only. The federal government plays the field, is what it's called. They occupy the field entirely. So, with them occupying the field, no state can have immigration law. Copyright law is the same, I believe, but let's stick with immigration. If any state has immigration, it is in direct violation, even if it is an exact replica, word for word, of the Immigration and Naturalization Act, INA. So, anytime a state copies INA, for instance, such as Arizona did a few years ago, it's still in direct conflict, and instead of being brought in line, it's just completely struck down because states cannot have immigration law. So, that leads to some complications with immigration enforcement. And what that means is that states aren't required to enforce federal law unless the federal government pays for it or the state agrees to use the resources. Now, back at the beginning, I said they can use carrots but not sticks. That means that they can incentivize states to enforce or cooperate in enforcement of immigration law through tax breaks, subsidies, mostly through the power of the purse. But they can't use a stick. They can't order the states to do it, and they can't coerce the states. And what I mean by coerce is where they can't cut funding by such a large amount that it would be considered coercion. The exact percentages vary depending on facts. You also can't cut funds from an unrelated source that was never tied to it. So, for instance, if Chicago doesn't enforce federal immigration law, well, the federal government can't cut all of Chicago's funding because it was never tied to immigration enforcement. There's also the thing with detainers, what you'll be called a detainer. I'll cover that a little bit more in the other video. But they have no legal binding because if they did, they would be forcing states to enforce federal law. So what can the federal government do? Well, they can always enforce federal law themselves. They can send immigration customs enforcement into a city, into a state, and round up people enforcing it themselves. They can pay to hire federal agents who work specifically in the federal government or in those state locations to do that work, but they're still federal employees. Or they can give subsidies and other incentives for states to do that, but again, states are never required. This is the quintessential states' rights issue, because no state can have immigration law. There's no excuse for a state to ever enforce it. So, federal government forcing states to enforce federal law would be a direct conflict with states' rights. So that's basically how this works. And an analogy would be with marijuana laws, with pot laws. Colorado has legalized weed. Well, it's still a Schedule I illegal drug on the federal level. All Colorado's pretty much saying is our police are not going to enforce this particular drug law. So if the federal government, the problem is if the federal government wants to come in and enforce that law, they can. Because both state and federal have laws on it, there would be conflicts. It's even simpler for sanctuary cities because states cannot have a law. So, these two things working together, the fact that federal government occupies the field with immigration law, and therefore no state can have any immigration law due to the Supremacy Clause, and that states are not required to enforce federal law, allows for sanctuary cities to exist on a constitutional level. So there's no real argument against why they couldn't exist. The arguments are more of should they exist, and we'll cover that in the next video.